There is a legal mechanism embedded in the United States Bankruptcy Code that can stop a foreclosure auction on the day it is scheduled to occur, not after the auction, not with a restraining order that takes days to obtain. On the day of the auction, within hours of the gavel falling, a single legal filing at any federal bankruptcy court in the country triggers what the law calls an automatic stay, an immediate court-ordered freeze on all collection actions, all foreclosure proceedings, all seizures of property, and all attempts to enforce any judgment against the debtor. The bank knows this mechanism exists. The auctioneer at the foreclosure sale knows it exists. The real estate attorneys handling the foreclosure know it exists. And in the overwhelming majority of foreclosure cases in America, the homeowner who's about to lose their house never learns it exists until after the gavel has fallen and the property is gone. The foreclosure industry processes approximately 100,000 properties per quarter in the United States, according to ATTOM Data Solutions. Behind each of those statistics is a homeowner who, in most cases, received little to no meaningful communication from their lender about the legal tools available to restructure their debt before the deadline passed. The servicer's financial interest is often not in keeping you in the home. The servicer earns fees from the foreclosure process. The servicer may have a relationship with the acquiring investor at auction. And the mechanism that Congress specifically designed to give distressed homeowners a breathing space to reorganize their financial situation is never mentioned in a single letter from the lender's loss mitigation department. Welcome to the Invisible Ledger. If these stories matter to you, hit subscribe and the bell. This is where we trace the money they told you not to follow. The automatic stay is codified in Section 362 of the Bankruptcy Code, Title 11 of the United States Code. It is one of the fundamental protections afforded to debtors in bankruptcy and applies immediately upon the filing of a bankruptcy petition. The moment the petition is filed with the bankruptcy court clerk, regardless of whether a judge has reviewed it, regardless of whether the bank has been notified, regardless of what time of day it occurs, the automatic stay takes effect and prohibits, among other things, the commencement or continuation of any action or proceeding against the debtor, any act to obtain possession of property of the estate, and any act to enforce a lien against property of the debtor. The specific type of bankruptcy that provides both the automatic stay and a realistic path to keeping the home is Chapter 13, codified at Sections 1301 through 1330 of the Bankruptcy Code. Chapter 13 is the wage earner's reorganization plan. Unlike Chapter 7, which is a liquidation that allows a trustee to sell non-exempt assets to pay creditors, Chapter 13 allows the debtor to keep all their property while repaying creditors through a structured repayment plan over 3 to 5 years. The Chapter 13 plan must be confirmed by the bankruptcy court, must be feasible given the debtor's income, and must pay secured creditors like mortgage lenders at least the value of their collateral. The mortgage cure provision of Chapter 13 is the specific tool that makes it so powerful for homeowners facing foreclosure. Under Section 1322(b)(5) of the Bankruptcy Code, a Chapter 13 plan may provide for the curing of any default with respect to a claim secured only by a security interest in real property that is the debtor's principal residence. This provision allows a homeowner who is 3 months, 6 months, or even 2 years behind on their mortgage to cure that entire arrearage over the life of the plan, typically up to 60 months, while making current mortgage payments going forward. The lender cannot refuse this. The lender cannot accelerate the remaining balance because of the pre-petition default. The automatic stay prohibits any further foreclosure action while the plan is in effect. The homeowner remains in the house. The arrearage is paid over time. And at the end of the plan, the mortgage is current and the foreclosure threat is extinguished. Before I go further, this video is just the surface. Inside the Invisible Ledger Vault, you will find the complete Chapter 13 filing checklist, the automatic stay enforcement guide, the mortgage arrearage cure plan calculation template, the bankruptcy court directory by district, the attorney fee benchmark by state, and the documentation you need to prepare before filing to ensure the stay is immediately effective. The link is in the description, but stay right here. The timing of the Chapter 13 filing is everything when the goal is stopping an imminent foreclosure auction. The automatic stay takes effect the instant the petition is filed, not when it is served on the lender, not when a judge signs an order, and not when the lender receives notice. The clerk of the bankruptcy court processes the filing, and the stay is operative from that moment. If a foreclosure auction is scheduled for 10 in the morning and a Chapter 13 petition is filed with the bankruptcy court at 9:55, the foreclosure is stayed. The auctioneer cannot proceed. If they do proceed without knowledge of the stay, any sale that occurs is voidable by the bankruptcy court. Many bankruptcy attorneys in states with high foreclosure activity offer emergency filing services, specifically because same-day filings are both legally effective and operationally achievable. A Chapter 13 petition can be filed with the minimum required documents, what practitioners call a bare bones filing, which includes the petition itself, the statement of Social Security number, and the credit counseling certificate. with the remaining schedules and plan to follow within 14 days under Federal Rule of Bankruptcy Procedure 1-7. This minimum filing is sufficient to trigger the automatic stay. The complete case is then assembled over the following 2 weeks, while the stay is in effect, giving the debtor and their attorney time to prepare a viable repayment plan. The credit counseling requirement is the one element that must be completed before filing. Section 109H of the Bankruptcy Code requires that individual debtors receive credit counseling from an approved nonprofit credit counseling agency within 180 days before filing. Many approved agencies offer phone or online counseling sessions that can be completed within 1 to 2 hours, and that issue a certificate immediately upon completion. A debtor who calls an approved agency in the morning can receive the certificate by noon and have an attorney file the petition the same afternoon. If you have made it this far, you understand the Chapter 13 automatic stay mechanism at a level that most homeowners facing foreclosure never reach before they lose their property. Subscribe and share this video. Now let me give you the critical timeline. Step 1. The moment you miss a mortgage payment and receive a notice of default, consult a bankruptcy attorney. Many bankruptcy attorneys offer free initial consultations. Do not wait for a sale date to be set. The earlier you engage the process, the more options you have. Step 2. Complete the mandatory credit counseling session. This takes approximately 1 to 2 hours and must be done through an agency on the U.S. Trustees approved list at justice.gov/UST/credit counseling debtor education. Step 3. Gather the documents your attorney needs for the filing: recent pay stubs, 2 years of tax returns, a list of all debts and creditors, bank statements, mortgage statements, and property valuation. Step 4. If a foreclosure sale date is set, communicate it to your attorney immediately. The filing must occur before the sale for the stay to prevent it. A filing on the same morning as the sale is legally effective but operationally stressful and depends on the court's processing speed that day. Step 5. File the Chapter 13 petition with the minimum required documents if time is critical. The automatic stay is effective immediately upon filing. Step 6. Within 14 days of filing, submit the complete schedules and proposed repayment plan. The plan must show that your income supports the required payments, including the current mortgage payment plus the arrearage, spread over the plan period. I need to be honest with you. The automatic stay is powerful but has limitations that must be understood. First, if you have filed bankruptcy previously within the past year, the automatic stay is limited in duration. Under Section 362C, a debtor who had one prior case dismissed within the past year gets an automatic stay that lasts only 30 days, unless the court extends it. A debtor with 2 or more prior dismissals in the past year gets no automatic stay at all. The bankruptcy system protects against serial filers from using the stay as a delay tactic. Second, the lender can seek relief from the stay under Section 362D if they can demonstrate that the debtor has no equity in the property and the property is not necessary for an effective reorganization. If the home is deeply underwater and the debtor's plan is not feasible, the stay may be lifted relatively quickly. Third, Chapter 13 requires consistent monthly payments throughout the 3 to 5 year plan period. If payments are missed, the case can be dismissed and the stay lifted, often with prejudice that limits future filings. The plan must be sustainable based on actual income. Fourth, Chapter 13 significantly affects your credit score. At Chapter 13, bankruptcy remains on your credit report for 7 years from the filing date. The impact is severe in the first few years and diminishes over time as you demonstrate current payment behavior. And fifth, the bankruptcy filing is a public record and is searchable in the Pacer Federal Court database. It is not a private proceeding. Your grandparents who owned homes during the Great Depression understood what it meant to face a bank that could take the roof from over their heads with a legal process that moved faster than their ability to respond. Millions of families lost their homes in the 1930s, not because the debt could not ultimately be paid, but because the legal process gave them no breathing space. Congress, in the Bankruptcy Reform Act of 1978, built the automatic stay specifically in response to that history, a mechanism that gives every debtor, regardless of their resources, the right to pause the machinery of collection long enough to present a plan. The banks know it exists. They count on you not knowing. There was not a more powerful tool. There was just one that required you to file a form before the gavel fell. Subscribe and share this video. Every share puts the Chapter 13 filing timeline in front of a homeowner who still has time to use it. The next vault opens soon, and what is inside will reveal how business owners can legally put their own children on the payroll, eliminate self-employment taxes on that income, and generate thousands of dollars in tax savings per year through a strategy the IRS explicitly allows.